Good afternoon, everybody, and you're very welcome to the last webinar in the 2021 series of the Victims' Rights Alliance, where we've explored various aspects of the needs and experience of victims of crime in Ireland. The Victims' Rights Alliance is an umbrella organisation of NGOs working with victims of a wide variety of crimes, everything from general crime through trafficking, road traffic accidents, homicide, domestic and sexual violence, and other areas of crime. I'm Maeve Lewis, I'm the CEO of 1 in 4, and I'm also the chair of the Victims' Rights Alliance. Today, our question is a victims of crime for Ireland. Should we have a victims of crime commissioner for Ireland? And I'm absolutely delighted to welcome two international speakers today. The first is Lev Altan, who is the Executive Director of Victim Support Europe. Lev has years of experience of the needs and of victims and the obligations of states across the European Union to provide support for those victims, culminating in the EU Victims Directive. And Lev will be talking to us from that position. I'm also delighted to welcome all the way from Australia, from Adelaide, Michael O'Connell. Michael is a consulting victimologist and is currently an independent decision maker for the Australian National Redress Board for victims of institutional abuse. But Michael was also the first Commissioner for Victims in South Australia and held that position from 2006 to 2018. So Michael is going to talk to us about the various functions of the Victims Commissioner, but also the practicalities of how that can operate in an effective way. Michael has kindly sent me 2 articles which he has authored and co-authored, and I'll be circulating them after the webinar. Just to say, they are not for public circulation, they're purely for your own information, as there are copyright issues involved. Each speaker will speak for 15-20 minutes, and then there will be an opportunity for questions, answers, discussion, and you can use the Q&A function on your screen to submit questions for the later session. So I'm delighted to ask Lev to speak first. So Lev, I'll hand over to you.
Thank you, Maeve. Good afternoon, everyone. Good afternoon, Maeve. Thank you, first of all, for this kind of invitation. It's really good to be able to talk about the issues. It's really nice to see some familiar names, if not famous faces, in the participants list. So I'm looking forward to speaking to you all and engaging on this. Just very quickly, for those of you who don't know Victim Support Europe, we are a European network of organisations working with and for victims of all forms of crime. We were set up in 1990. We now have more than 60 members in 31 countries, and they together are supporting in the region of 2 million victims every year. And what VSE does is it works really to develop the policies and to advocate for the rights of all victims, both across Europe, but globally as well. So we work with the European Union, with the Council of Europe, with the UN. But we also do a lot of capacity building work to help organisations develop their own capabilities, to help governments implement legislation and policies as well. And we also carry out a lot of coordination and networking. So we have an online hub for organisations to come together. We have a training academy, for example. So that's just a little bit about ourselves and the context. What I wanted to just quickly run through is a little bit about I suppose, the context of victims commissioners, both from the perspective of EU victims' rights, but then what we've seen and experienced in the implementation of those rights, and I suppose really where does the concept of a commissioner fit, and what is necessary to make it work. So if I start quickly just with the victims' rights legislation, I suspect a lot of you already know this, but there are multiple European Union legislations in place for different groups of victims. There's an overarching directive, which for shorthand is called the Victims' Rights Directive. It was adopted in 2012 and came into force in 2015. That is applicable and enforcement in Ireland, and it really establishes the the detailed framework for how all victims of crime should be treated in Ireland and in every EU member state. And it has a needs-based approach, which is extremely important. It's structured around the 5 needs of victims as Victim Support Europe has summarized them. So that means that victims are entitled to be treated with respect and dignity. They're entitled to be recognized. They are entitled to be protected from further victimization, intimidation, harassment, but also from secondary victimization within the proceedings and by support organizations, for example. They're entitled to access to justice and to forms of compensation. And within the entitlement to support, they're also entitled to information. So that has provided a framework for victims' rights that should have been in place in all member states of the EU by 2015. And implementation has been highly variable, including in Ireland. There are aspects where it's going better, some aspects where it's going worse. So I won't spend time really going into those details. We know it took a while for Ireland to really put in place the legislation and be implementing things. And I think there's lots of ways in which Ireland can really make good progress. You have a lot of the strong foundations there, but interestingly for me, I think some of the aspects of what inhibits faster progress in Ireland is related to some of the concepts around having a victims commissioner. So I think I'll move on to a little bit around that now. So when we're carrying out our policy work, we've really been trying to help people understand and to work out ourselves, how do you actually achieve change in a country? How do you ensure that these European rights or international rights that have been established are actually put into practice? And we see that from 3 different levels. We see that from the perspective of leadership. So you need to have the right leadership, and you need to have leadership which is assigned to taking forward victims' rights in place in any country, and they operate to give inspiration, but they also operate to prioritize the issues and to coordinate as well. So leadership is a critical aspect to change, as is the infrastructure, the laws, strategies, policies, the specialist bodies which are in place in any given country, which helps take forward those victims' rights and make sure that those rights are real and enforced in practice. And then the final level is really on the personal level. So how do we as individuals change? What is the behavior change that is necessary to ensure that victims are treated in a proper manner and have the rights that they need as well? So those are the 3 levels that we see of change. And again, the role of victim commissioner actually operates in all 3 of those, and what makes a successful commissioner is reflected in those 3 different levels, including the personal characteristics and ambitions and desires and inspiration of any given commissioner. And what VSE has done over the years is, as we've carried out analysis, we've done, for example, a project called Vociari, where we've analysed the implementation of the EU Victims Directive in every EU member state, including Ireland. And as we carried out that analysis, what we saw was that when it comes to the concept of support for victims, it's not really enough to talk about victim support as some kind of organization. You actually have to talk about the entire framework for victim support. If I just quickly share my screen, let's see if there we go. So what we've produced is this national framework for comprehensive victim support. Hopefully you can all see that. Hopefully you're not on mobile phones and squinting. And the concept of it is that in any country, in Ireland, you need to have an entire framework for delivering support and delivering those rights in particular. It starts with the victim at the centre, ensuring that they have the resilience and can cope themselves, but also ensuring that their social support network is in place and is strengthened and knows how to be supportive. And then you see those arrows there, which is effectively saying that support is everyone's job, that you have victim support organizations who support all victims of crime, you have specialist organizations that maybe support certain groups, but you also have societal services, justice and law enforcement who should have specialist capability to engage with victims and meet their needs as well. The bit that's relevant for this conversation is actually really at the top there: oversight, monitoring and review. And effectively what we have seen, and if I stop sharing this now, what we've seen is that really the countries which have independent mechanisms and coordination structures for taking forward victim policy and victims' rights, the ones who tend to have a consistent long-term progress on victims' rights and can properly address that in a coordinated manner. And that's really important because historically, I think what you can see across, I would say, any country across the world, is that victims' rights tend to be in the area of start-stop. That means that one government may be interested and prioritize the issue. There may be some significant case, often a historical child abuse case. Suddenly there's a movement, a momentum for change. And then once all of that dies down, then the interest goes away, the funding goes away, the progress on rights goes away. So this is an area where you need to have an infrastructure which continues progress, irrespective of which government may be in place, because we understand that it's part of our social fabric. The implementation and delivery of victims' rights and victim support is really a bridge between effective criminal justice responses and effective social welfare and social cohesion responses. So we need to have those together, and it's not something, it is apolitical. If you have the evidence in place, you have all those. So where does that lead us to when it comes to the notions of a victim commissioner? Well, effectively what we have seen is that if you have some kind of a body, some kind of a person operating independently, whose role really is to provide advice to government, provide advice to individuals or to organizations, to review how rights are being implemented, to develop policies and law, to develop advice on policies and laws, to develop the evidence base for those kinds of activities, then you tend to have a much stronger infrastructure for victims themselves. So some of the key aspects to what we've seen is important. The starting point is to be clear who this person is, how you appoint that person, and what is their role and what are their functions, and the decisions you make about that can make a fundamental difference to how successful they can be in advancing victims' rights. The more independent that person is, the better. They tend the victim commissioner position tends to work best when it is this bridge between the state and civil society and victims, where that person can talk to government in a position of trust, but equally to victims and NGOs, but is able to challenge the status quo, is able to challenge what is happening, not in a negative way, but in a constructive way, and trying to really progress things. And it creates effectively something of an advocacy function, where you give victims a voice, where you're able to raise awareness and demonstrate priorities, but you're able to also have a role of developing the research and knowledge in the field. And then in some countries, the added benefit can be, or added role can be, where they have an individual assistance role, where that might be investigating individual complaints, for example, similar to what an ombudsman may do. That doesn't always happen. I don't know if any of you've seen the Northern Ireland consultation and the fact that they want to appoint a victims commissioner. They are one of the countries which have chosen not to have that investigative or review function. The Federal Ombudsman of Canada is similar. what they have focused on, and what is particularly important is that they're able to operate in a coordinating function, that they're able to help bring together the multiple actors that are involved within the victims field. And that means, in particular, helping bring together state actors and non-state actors. We see often in a range of different countries that civil society and the state don't really talk as much as they need to, and they don't necessarily talk in an environment of trust and cooperation. And where we've gone into those countries to organise national meetings, for example, in Greece or Italy, or we're going to hold one in Estonia, our kind of neutral position, which is really about how do we help society improve the way it functions for victims, helps bring those actors together, almost like a moderator. And that's something that we've seen. I think it was expressed by the former Commissioner for Victims of the Troubles in Northern Ireland, Judith Thompson. She felt that was an important role she had in Northern Ireland in her job, was to help bring these different actors together and to coordinate thinking, and to bring together the knowledge and advice that's necessary for government to know how to do their job well. And for me, that's a fundamental function of what a commissioner can do, which is to support the policy-making cycle, the policy cycle, and to support evidence-based policy making. Because the vast majority of the best practices and the ways of implementing victims' rights are really not controversial, or there's not really so many grey areas when it comes to the fundamentals. Whichever side you come from, whatever political persuasion you have, it tends to be that you can use an evidence and research-based approach to come to a fairly consistent set of conclusions about what needs to be done for victims. So that's an important role for commissioners, as is giving victims a voice. We always say that really you can't do effective victims work, you can't really advance victims' rights without listening to victims. But it's not necessarily always easy for governments and others to develop consultation processes where victims trust that process, but where also they're enabled to speak in a way that they're able to. So, government officials, policy officials, we all have our ways of thinking and working. Usually for victims, all they want to do and shouldn't have to do is say what's worked well and what's not worked well. And it's for the rest of us to work out how to solve those issues and how to progress the positive things as well. So a commission position is a really important body to help bring people together, to help them express their issues, to gather the evidence and the knowledge in order to then start developing recommendations and proposals. And I think the other bit I would say, I don't want to take up too much time. I didn't check when I started, but I think I've probably got a couple of minutes left. I think is around the review of the existing systems and the monitoring. And when I showed you that National Victim Support Framework, that monitoring and evaluation is really critical. And having a body that's independent but is recognized either in legislation or has some kind of formal recognition by the state, to look at the different bodies and their responsibilities and to look at how they're doing their jobs and whether they're doing those jobs in a good way, and to support the process of review. If you don't have that kind of process in place, it's quite hard to make progress, particularly so for victims of crime, because it's pretty rare for victims of crime to have effective legal remedies where there is a failure to uphold their rights. And this is something that we see as a fundamental problem. It's something which we are pushing for the European Union to make progress on. If you're a suspect or a defendant and your fair trial rights have not been upheld, you have very clear, very strong legal remedies. which are transparent and which are supported through the provision of legal aid. When it comes to victims, it's a highly variable situation, and many victims in many different countries barely have any legal remedies. When you have victims' charters, they've made significant progress. But really, when your rights aren't upheld, what can you do when that charter fails, and what is done, and how much change is achieved through basic review processes or complaints mechanisms? So I think that's an important aspect which doesn't necessarily relate to an individual case, but a commissioner's role can be to look at how, let's say, the judiciary, well, maybe not the judiciary, but let's say the police system functions, or how the reporting process functions. We know that there are many victims who never report a crime. So how do you review that? How do you look at how it could be improved? So in some countries, you have different inspectorates that look at these things. A commissioner can have that role and have the perspective of the victim when they're carrying out that role. So I think that's enough for me for now. It gives some level of overview. I didn't get into the details on who. I think that's much better provided by Michael and some of the complexities of ensuring independence as well. But I can say this. The most successful commissioners, such as, in my opinion, Michael, Judith, and Sue O'Sullivan from Canada, part of what makes them successful or relevant, really relevant to victims, is their own personal passion and commitment to helping victims of crime. Finding those people who really care is an essential element in, I would say, the job description of a commissioner. So I hope that's a helpful start in any case, and I'm happy to take questions.
That's great. Thanks very much, Lev. And we will wait until after Michael's contribution to take questions from everybody. But that was really interesting and challenging indeed in the Irish context. Thank you so much. So I'd like to hand over now to Michael, all the way from Adelaide. So Michael, the floor is yours.
Thank you very much. And I'm going to show some slides and talk to those. Just to make life a little easier for people who are not familiar with the Commissioner's role in South Australia. So let's hope this all works. Very good. All right, so just very briefly to put this into some context, what I have to say, South Australia was the first of the Australian jurisdictions. There are 6 states and 2 mainland territories. South Australia was the first of the Australian jurisdictions to implement, well, to introduce rather than necessarily implement, because they're fundamentally different, a declaration on victims' rights, and that was done in 1985. And 2 years later, it was proposed to appoint a coordinator for victim impact statements, whose primary focus would be on buttressing the right the victims had to make submissions during sentencing through the victim impact statement, and to review that process. The position, however, was not independent. It was decided to position the Victims of Impact Statement Coordinator within the prosecution service of the South Australia Police, so somewhat like the Garda in Ireland. A decade or so passed before the government of the day, a Liberal Conservative government, decided to appoint a Victims of Crime Coordinator, who they determined would be a statutorily independent person. Now, South Australia is a former colony of England, and as a consequence of that, we have adopted and adapted the Westminster system, and the monarch in our jurisdiction is replaced by the governor. And the governor was tasked with the responsibility of appointing the Victims of Crime Coordinator, whose primary functions were to advise the government on how to best use its resources to match the needs of victims of crime, and to carry out functions that the Attorney General, who's equivalent to the Minister of Justice, might from time to time assign. In addition to that, to monitor and review the actions of government institutions such as the police, such as the prosecution and the courts, and provide advice to the government of the day through the Attorney General on what reforms might take place. We had a change of government from a Liberal Conservative to a Labor Democratic type party, and they were elected on a basis of a law and order agenda, among other things, and in that agenda they began to use the mantra that victims should no longer be bystanders in the criminal justice system. They also had the benefit of inheriting a blueprint, the results of an inquiry called the Review of Victims of Crime, which in a 3-volumed report had come up with quite a number of recommendations to enhance victims' rights, for example, to move them from an administrative direction to enshrining them in law, to introducing more stringent requirements around the training of public officials and other things around the issue of professional development, and not least recommending that all of the chief executives for the various justice agencies have written into the terms of their contract of employment obligations to implement victims' rights and to be called to account whenever those contracts were under review. Now that part of it has never to this date been formally followed up, I have to say, but it did win the support of the chief executives of the day across the police, correctional services and the Courts Administration Authority. In the second term of the Labor government, they decided to have their own blueprint called Justice for Victims of Crime, and in that they announced that they would have a Commissioner for Victims' Rights. And the concept of a commissioner had been promoted by the Victims of Crime Coordinator, who happened to be me, as a consequence of the government asking the Victims of Crime Coordinator to perform functions that were outside of the traditional brief of someone who's tasked with essentially giving strategic advice to the government of the day. For example, the Victims of Crime Coordinator was being asked to deal with daily with individual victims, to look at grievances that victims had, to provide advice on what might be done to strengthen victims' participatory rights in the criminal justice system. And so in response to the various submissions that I made, the government decided that they would create a Commissioner for Victims' Rights. And for that purpose, they looked at the different types of independent people or independent victim type people that existed around the world, such as the Tony Blair proposal to have a Commissioner for Victims and Witnesses in England. And one of the things we adopted from that position was the relationship between the Commissioner for Victims' Rights in South Australia through a minister to be able to report direct to the cabinet of the day, of the government of the day, to be able to provide strategic advice independent of the government of the day. We looked at the Commissioner in Northern Ireland, and at that point in time, the proposal for the Commissioner was looking very much at the role that the Commissioner could play in improving victim assistance programs to ensure that they better match the needs of victims of crime. So it was determined that a Commissioner in South Australia should have a function around advising on resourcing and the like. And then we looked at, for example, the proposal to have an ombudsman in Canada and what functions that person would have, and in 3 or 4 different state jurisdictions in the United States, and looking at the role, for example, there was an ombudsman who could inquire into alleged breaches of victims' rights, and if the commissioner, the ombudsman in this particular state determined that there'd been a violation, could order a penalty of up to $1,000 American to be paid by the public agency rather than by the individual. So what came out of the mix of this sort of international inquiry? Well, in terms of the commissioner's role, it was decided that the commissioner must be independent of the government of the day. And so the practice of having the governor representing the monarch making the appointment carried over, having a commissioner whose term was up to 5 years meant that if the commissioner was appointed on or about the time that the new government was elected, then in South Australia we have fixed government terms of 4 years. So the commissioner would outlast the government of the day, which was seen as being critical if the commissioner was going to be a critic of the government of the day, and I mean a critic in a constructive way. It was decided that the only person who could terminate the commissioner's position would be the governor, and there would be specific reasons that could be done. So it wasn't just a matter of the government of the day getting fed up with the commissioner talking about a particular issue or contradicting their policy, and a representative of the government going down saying to the governor, get rid of this person, we don't want them anymore. The governor had to actually be convinced of any of the criteria, such as guilty of misbehaviour or criminal conduct, bankruptcy, and the like. It was also decided that the commissioner, once appointed, would not be a member of the public service. So therefore, the normal restrictions on a public servant, for example, not being able to deal with the media, not being able to publicly express one's opinion or views or thinking on a particular topic, all of that would not bind over the commissioner in South Australia. It was also decided that because the commissioner, in order to be able to communicate with the government of the day following the conventions of the Westminster system, had to report through a minister of the government of the day, that there needed to be a way of separating out and ensuring that there wasn't undue ministerial influence on the role of the commissioner. And so that they searched for a way of setting that up and decided to follow the model that we have here in South Australia for the Commissioner of Police. That is, that if the Attorney General or the Minister for Justice, the minister to whom the Commissioner reports, decides to try and direct the Commissioner to do a particular thing, then the Attorney General, as the Minister for Justice, must table that direction in both the houses of the Parliament and also publish it publicly in the Government Gazette. In other words, make it clear, in terms of transparency, that I, as the Attorney General, have interfered with the independence of the Commissioner for Victims' Rights. And finally, because always in politics, the power of the purse can be influential, the law provides that the commissioners and his or her staff's salaries, wages, must be paid from the Victims of Crime Fund. So the Victims of Crime Fund is a quarantined, administered fund that helps subsidise the costs of victim services, state-funded compensation, and the Commissioner's office. And that money cannot be used for any other purpose. So it sort of helps ensure that the Commissioner is not caught up in that annual fight to secure adequate money for the basis of running the office. Whoops, sorry, jumping too quickly. So what does the Commissioner do? Well, I've already given you some hints. So one of the functions is to advise on how effectively to use resources. Another is to actually assist individual victims in their dealings with the prosecution authorities and any, in fact, government agency. And that became one of the primary areas of activity for me when I served as the Commissioner, to monitor and review law. And as a consequence of that monitoring and reviewing, I found myself being called to give evidence to government inquiries, to royal commissions, even going down to judicial gatherings for the purpose of providing submissions. And quite often submissions were being made separate to the submissions of the government of the day. It wasn't my function as a commissioner to sit with the government of the day. If they were proposing a new piece of law, then I would go down as an independent person. To carry out other functions consistent with the objects of the Act, that's just a global provision. It was a legacy of the former position of the Victims of Crime Coordinator that I mentioned. To be able to appear in certain criminal proceedings, to make submissions either in person or through legal counsel. This still to this day, it's only the Commissioner in South Australia that has this right to intervene at certain stages of criminal proceedings and make submissions. And to be able to, and finally, Lev mentioned the ombudsman type function. Well, in addition to having all of those functions I've just outlined, they decided, the government of the day and ultimately the parliament that enacted the law, that the commissioner should also have an ombudsman type function. And this ombudsman type function, where the commissioner can consult a public official or a public agency in relation to a victim's grievance, and then if the commissioner determined that the grievance has been substantiated, in other words, a right within the declaration governing the treatment of victims of crime has been violated, then the commissioner can recommend either the official as an individual or the public agency make a written apology to the victim. And an inquiry in one of the other jurisdictions of Australia determined in its conclusion that this was the first step towards having enforceable rights anywhere in Australia. That is, where there is a right that creates an entitlement or specifies that a victim is owed something as a consequence of their status as a victim of crime, and that is not met, then there is a process of review, and that review results in some form of remedy, in this case, an apology. Interestingly, in the preamble to all of the legislation that supports this, it specifies that no matter what the commissioner determines, it doesn't give rise to either a criminal or civil action. And finally, just in terms of the law, before I get down to some of the practicalities, we have a very global general section in our Victims of Crime Act as well that allows the victim to appoint an appropriate representative to exercise any one or all of their rights as a victim of crime. And one of the key pointers here is that the Commissioner for Victims' Rights powers were expanded as a consequence of this section, and also helped to buttress the role that the Commissioner played in assisting individual victims in their dealings with proceedings. And it essentially means that the Commissioner, either in person or through legal counsel, can represent an individual victim or can appoint a legal counsel to represent the individual victim, for example, in a charge bargain session where the prosecution is communicating with the victim and saying, this is our evidence, this is the submissions that have been made by the defence, we are contemplating accepting a plea to a lesser charge or whatever, what are your views on it, etc. Well, often the prosecutor is a lawyer, the accused person has a lawyer, the only person sitting at the table who doesn't have the assistance of legal counsel is the victim. So this was a very important way of introducing some sense of equity into the system. Now, unfortunately, you have to look at me again for a little while now. So in terms of some practical pointers to think about, I began with addressing the issue of the Commissioner's independence. Well, it's important that one acknowledges that independence of itself, it does not mean that the Commissioner can fulfil his or her functions to the exclusion of anyone else. In fact, whilst independence literally means that one is not influenced by or controlled by others, it's actually important that the Commissioner is engaged with the victims of crime, whether they be individuals, whether they be victim assistance organisations, and that includes both government and non-government. The Commissioner cannot afford to be isolated from that connection of the other people. In fact, when it comes to individual victims, I often argued that the role of the Commissioner was to amplify the voice of the individual victim, not to replace it, but rather through amplification to strengthen it so that the victim came away feeling that they had been empowered, that not only had they been given a voice, but they had attained voice recognition, to use the computer jargon, and more importantly, because often the Commissioner was seen by the very status of the appointment to bring some clout with him or her, in my case, him, then in those circumstances, it sort of added some weight. It sort of buttressed and magnified the position in terms of the status that was given to the victim and the recognition that's given to the victim. So to give you a very quick
Michael,
example,
you have 5 minutes.
5 minutes, all right. Some other quick pointers then are that I found that that whilst one had a strong and independent voice and certainly legislation to support it, that it was wise to be often politically diplomatic, to work with parliamentarians rather than consistently against them, to go down to the parliament and meet with the various people, whether it be the advisors, the ministers, the opposition members, and talk through the issues with them and provide them with a knowledge base upon which that they could develop their policy. I used to always say to them, I will come and tell you the arguments for and against the position you are taking. I will come and tell you what the research shows about it, but I will not write the policies for you. You are the democratically elected people, and as a consequence, you will be the people who are held to account if the public don't like your policy. So I always made sure that there was that distinction. I think the Commissioner has to look upon him or herself as someone who is an influencer, who is trying to foster change, and occasionally that means you have to actually try and drive it and push it along. But you do really have to bring people with you. You cannot create a circumstance where there is friction. And although victims often are very anxious and desirous of rapid change, I mean, I just remind, particularly victim advocacy groups here in Australia, I remind them that our first charter on victims' rights was 1985. So in some 30 or 40 years, we've actually had some quite remarkable change when you consider the 200 to 300 years beforehand, when victims were relegated predominantly to be mere witnesses for the prosecution, and all that went on then in terms of gradually taking away the entitlements that victims have. I think we always have to be aware of the political context within which we're operating, and be wise to that, because with that, or a failure to understand that political context brings with it, for example, the risk that one won't be reappointed. And in my case, we had a change of government here, and a decision was made not to reappoint me after some 12 years. I think a commissioner is in a very good position to bring people together, and Lev explained that very well. A commissioner has to gain trust of victims, trust of victim support agencies, trust of the various institutions of government, and trust among parliamentarians. And if you betray the trust that is extended to you, then that not only demeans the position, but the position in terms of its influence begins to become unravelled. And I think, as I said before, being politically wise is really, really important. And when all else fails, the media, working with the media is important. It's important in an educative sense, because you want the media to report accurately. You don't want the media through its reports to do any more harm. But you cannot separate in a broad political sense the whole debate around victims' rights and improvements in victims' assistance, etc., from the interest of the fourth estate, that is the media. So setting some parameters around how you will work with them, etc., is really important. And finally, by way of a closing point, I spent most of the last 10 years of Commissioner on call 24/7, and my other peers who were Commissioners or Ombudsman have found that incomprehensible. But what I learned is that if you can be readily available to address victims' practical and material needs when they want them, then you have a better chance of reducing the probability of a second injury, that's secondary victimisation, as a consequence of their emotional and psychological responses to the various things that happen around them. And prime examples of that are providing crime scene cleanups. So whenever there was a homicide, the police would contact me and I would arrange cleaners to go in and clean up the crime scene, so that by the time the victim's family returned to the household or the crime scene was released, it was back as best as possible to the state that it was prior to the crime happening. And it's interesting, though, those very practical material ways of assisting victims were actually some of the things that gained the most impetus in terms of winning over victims and winning confidence in the office of the Commissioner. Being there to match victims' needs and help fulfil their rights most probably are, for me at least, while I was the Commissioner, two of the most fundamental things that a Commissioner can do and can make a difference in. Thank you for your time and trouble.
Thank you so much, Michael. And what we're going to do now is to throw open to the floor, and we already have some questions. I'm not sure if have we lost Lev there in some way?
I'm here.
Oh, you're here. Great. Okay. So some of the questions are to each one of you, others would be general. One of the things you both touched on was the notion that a victim cannot be a bystander. Now, Ireland is the last common law jurisdiction in the EU, and we have a very adversarial system of criminal justice. Would either of you have thoughts about how it's possible to balance the rights of victims in line with shifts in the understanding of victims' rights with the very high constitutional protections that are in place, certainly in Ireland, for alleged offenders through the criminal justice system? Because that is certainly a perennial question here for victims who engage, especially at the level of the trial.
Do you want me to go first?
Yeah, Lev, please, yeah.
So, I mean, this is a really important issue. We're actually just in the process of preparing a policy paper or a discussion paper, maybe, on a concept of safe justice. Because what we want to really start a discussion on and is what actually, how do you measure success in justice? So, you know, over the last 100 years, our justice systems have been designed having in mind authoritarian states and the harm that's been caused to innocent people and the abuse of power. And as a result, we measure justice at the moment primarily by finding guilty people guilty, trying to make sure innocent people are not found guilty, and making sure it's all done in an efficient manner. These are our main ways of judging how successful our systems are. And our view is that we now are at a stage in our development in our Western democratic societies, at least, where we should be reviewing what are the measures of effective justice, which should include a victim-centric perspective and can include legitimate discussions about the role of victims within the justice system, including discussing the role of jury, including, you know, adversarial proceedings versus giving victims standing within the judicial proceedings. I think all of that is up for grabs. I don't think it's a constitutional question, and I don't think necessarily it's even a question of defense rights versus victims' rights. Some of this is the balance of power, where there is there was a decision made that it is the state acting on behalf of society to combat crime and to pursue the criminals, and all of those things can be reviewed and looked at any time, and they have been done. Putting all of that aside, you can still achieve significant strides in terms of victims' ability to participate in justice without even changing their formal standing, and that's critical. We see that what you need to do is have systems in place which ensure that victims are able to report the crime, that they are treated in a proper manner throughout the whole proceedings, and that they can participate in different ways. And I think we can even expand the notion of the level of participation. In a common law countries, you know, we've got to the point where we've accepted impact statements, but I don't see why we can't be examining the extent to which you can give victims some ability to seek that certain evidence is taken into account, or at least collected. We managed to get through the EU Victims Directive the right to review a decision to not prosecute, for example. So we can push those boundaries, but the starting point is to really understand why those boundaries exist, and are they still necessary, and what are the consequences of moving those boundaries in some way. So I think that there's a huge amount of potential. Maybe part of the starting point is looking at certain types of crime. I think when you look at sexual violence, rape cases, for example, and you look at the harm that is caused to a victim. We have a victim speaking at our conference on the 3rd of December, German lady who's a victim of rape using a date rape drug. And, you know, she had a fundamentally terrible experience through the process, to the point where she says the experience she had with the police was worse than the rape. Now and I believe this sort of situation happens in Ireland, and you cannot say that that isn't acceptable. You have to fundamentally review what's going wrong with your justice system when victims say that. So that's a long answer, but I think there's a lot we can do.
Yeah, and very relevant. A lot of our clients would say that the experience of the trial was as traumatizing as the initial experience of child sexual abuse, which is damning. Do you have anything to say about that, Michael, that question?
Just, I don't dispute anything that Lev said. What I actually found one of the most convincing ways to bring about change, we have the law to back us. A victim in South Australia, for example, has a right to make their safety concerns known to a bail authority before a suspect is released on bail. The question is, how do you do that? A victim had a right to be consulted on a charge bargain. A victim had a right to has a right to make a victim impact statement and to make submissions to the parole board, either in person or in writing. So we had that law. The question is around the efficacy of its implementation. And if we just take the idea of victims having their own legal counsel, what I determined to do was to go out and choose the best criminal lawyers who supported defendants and ask them whether they would do work to assist with victims of crime. And some of them refused initially. Others said, well, I've never done it before, this might be interesting, let's try something new. And ultimately what happened is that by the time, and we're talking some 10 or more years, by the time I finished my position, the strongest advocates for me continuing in my employment were the Criminal Bar Association that represented defendants. And why? Because contrary to their initial perception, the sky didn't fall in, better outcomes were being achieved, better decisions were being made around the sort of charges that should be progressed, etc. And what's more, there weren't placard waving people in front of courthouses demanding that people be executed or put in prison for life, etc. Because people were not only being given a voice, but that voice was being acknowledged. And finally, to a couple of examples, prosecutors, even now that I'm retired, call me to ask for advice on a lawyer who might assist the victim in a particular area of discussion. And we've had some judges who have stopped proceedings here as a result of seeing and learning from the experience of my interventions, and have said to some, well, in one case, they said to a lawyer, you often represent victims. This victim needs a bit of help. Can you come into our courtroom and give her some advice? So I think winning over the opposition in a nice way. I mentioned political diplomacy before, and I meant political in a small p sense, and choosing the right people to demonstrate that you will not damage the system. In fact, you will enhance it, you will improve it, and that's my experience.
Thanks, Michael. Yep.
So just to pick up on Michael's point, this idea of accompaniment, both legal and support, is, I think, really critical. We're part of the evaluation of the Victims' Rights Directive, and there's a lot of feedback about the impact it makes when a victim is accompanied by some kind of official person in terms of the way that they experience their rights. So when a victim is accompanied by a victim support organisation to report a crime, they're much more likely to be listened to have their complaint dealt with in a proper manner. It's the same, I think it was Victim Support Sweden was talking about, where lawyers are involved in supporting the victim throughout the criminal proceedings. Actually, the prosecutors really appreciate it. It takes a lot of work off them because victims are able to do in sort of UK parlance, they're able to give best evidence, enable best evidence. But they're also better supported, and sort of specialist victim lawyers start also taking on that sort of practical emotional support aspect, which is complemented by victim support and by the specialist. So accompaniment, even if you don't change any fundamental rights within the system itself, having some formal person accompanying throughout that whole process enables those existing rights and the participation process to be handled in a much better way.
Right. We're going to run out of time, but then there's a load of questions in. But one, I think, which I'll put to both of you. One is, I suppose, for you, Lev, and you'll have to answer quickly. Is there a model European country Ireland could emulate? And for you, Michael, in the 12 years that you were Victims Commissioner, what really changed for victims of crime in South Australia? Now, we could talk all day about that, but very quickly, what would your, say, Lev, is there a model European country?
I think it depends what you're looking at. So I think you've already got, I think the combination of the roles of the commissioners in London and England, in Canada, South Australia, and to some extent the Federal Commissioner for Victims of Terrorism in Germany. These are all already good examples of countries that are doing something when it comes to commissioners. I think if you're talking about the operation of victims' rights, you can take certain things for different places. The Nordic countries tend to have pretty good systems in place. The Netherlands, France, these have good systems in place. When you're talking about that framework, you need to, ideally you have a strategy, you have a coordinating body, some kind of committee which brings together governments and NGOs. You have your commissioner, and then you have a law in place, and then you have the enforcement mechanisms. You have detailed protocols for referral systems. So there's so many different parts to that it's about taking those different aspects and bringing them together.
Bring them all together.
Sorry.
I have to stop you there. And Michael, and very briefly, there's one more question we have to answer. So what difference did you make with all your work?
Twofold. One is that we expanded victim assistance programs to a statewide network for both specialists as well as generic victim services, because I think running parallel to the developments around victims' engagement with the criminal justice system, there are a whole range of other needs that have to be met. So we mustn't lose sight of that as well. And the second was that victims were seen to be a genuine participant in the criminal justice process. They were not considered a party, and that's my biggest regret after 12 years, but at least they were considered to be a genuine participant worthy of having a conversation with, and I would see that as my legacy. And I noticed one of the questions that got asked in the chat very quickly, that one of the readings that you were going to give out.
I'll just
address that question.
I'll just pose that now to both of you as the final question. What is your advice to us here in Ireland in terms of persuading the government that we need a victims commissioner? Great question.
Michael, you go first.
Well, see, we were fortunate in South Australia that we had a government. We've had both a Liberal Conservative and a Labor Democratic party, political parties, our major political parties, for 3 decades, sharing an interest in improving the circumstances, the position, the sort of assistance that provided to victims of crime. So we were able to build on that momentum. And I don't know enough about Ireland to know if you have that momentum. But what I will say to you is that in all the other jurisdictions in Australia that I went to as a consultant, when I told them the same story I've just told you, at least one half of them said, we will never have a commissioner who will do the things that you do because we don't want to be called to account in the same way that your parliamentarians are. So I suggest that you have to step with some level of caution, but keep working at it.
Well, there is some impetus in Ireland in the area of sexual crime, partly because of the Belfast rape trial that you may have been familiar with. As one of you said, I think you and Michael start. There was outrage here about what happened in a different jurisdiction, but very similar to the courts, and that has provoked a great deal of change. Lev, your thoughts? What do we need to do?
Yeah.
How could the EU help us?
Well, I think the EU can have us. I think you can be lobbying the EU. So the EU, there's two parts. One is that the EU will be publishing a gender-based violence directive in the new year, so that there may be a place there to really push for inclusion of something around commissioners on that side. But probably even more relevant is that the Commission is currently considering whether to amend the existing Victims' Rights Directive. And this is an opportunity to really lobby and advocate for something to be included on that. We're really pushing things from the perspective of coordination mechanisms and oversight mechanisms, taking into account, for example, the human trafficking national referral mechanisms, which talks about a coordinator, and it's already the start of the idea of a commissioner. So I think that there's plenty you can do there to really push the Commission to change, because a lot of what a commissioner does is really help implement existing EU laws, not just the Victims' Rights Directive, but human trafficking, sexual exploitation and others. I think that at the national level, the starting point is to start coming together, not just one or two organisations, but all the victim organisations, of which there are many in Ireland, and have a single voice on this, but get together with all of the women's organisations, disability groups, LGBTI groups, etc., so that you're able to say, look, if the government is serious about this, then this is one of the major ways that they can make it happen. But also to do some of the stuff which Michael sort of explained, which is about showing how a commissioner is not in opposition to the government, it's actually in support of the government. And I think that over these many years, what you see in Ireland is that you've had this body that's supposed to be taking victims' rights forward, but they're not really funded, or they haven't had the staffing, or they've not had the political prioritization to really coordinate and take things forward. Now, a commissioner position would actually fundamentally help them to do that. It would take a lot of that pressure off. All they will see over the coming years is more and more pressure and dissatisfaction with the system. And they should also be realizing that they're falling further and further behind member states of an equivalent GDP. Ireland was a primary supporter of the victims legislation during negotiations, which is, I was in the European Commission negotiating it, and they were really strongly supporting it. Now, kind of, they need to work out how to put this in place. And part of our job and your job is to help them understand why a commissioner will help them do that, and give them the evidence base for how it works, how it operates, and why it works well. You've already got the Northern Ireland processes and the English processes to fall back on. If they can do it, how on earth can you not have that in Ireland?
Thank you, Lev. And on that note, unfortunately, we're going to have to finish. I think we could speak all afternoon about this. So to thank everybody who attended the session, but especially to thank Lev and Michael for taking the time to be with us today. We will be organising another series of webinars next year, and I think this certainly is an area that we will need to return to. So Michael is kindly going to forward his slides, which we'll disseminate to everybody who attended, and likewise the articles and the chapter that Michael sent to me. So guys, thank you so much. I wish we could continue, but really appreciate you taking the time. Bye.
Thank you very much.